for hearing item numbers 1 and 2.
Please, Your Lordships. As per the last order, the learned CGC was instructed to come with some instructions. And I'm told that he has received some instructions. However, the council is indisposed. So if it can be listed in the next division page.
Mr. Jamil, what is the matter about?
The matter is regularization, Your Lordship.
And
The petitioner respondents, they were serving as now assistant horticulture specialist, Your Lordship. They were appointed with advertisement both in local newspaper and in national newspaper, Your Lordship. And then they've been serving, but they were appointed on contract basis. They've been serving for more than now 19 years, Your Lordship. And then in the meantime, the respondent.
so you were appointed for 18-19 years.
Yes.
Now they have issued an advertisement. So you have challenged the advertisement.
Yes.
Why?
I have challenged the advertisement. Yes, Your Lordship. In fact, unless I challenge it, because it amounts to my termination service, Your Lordship.
Against your post.
Yes.
No, your right of regularization is different from the fact that you are being as regards the post, the advertisement. They want to regularly fill up the post.
No, Your Lordship, it was a sanctioned post. I have been appointed against the Senate board by way of advertisement.
But the fact remains, there's no direction passed by the court to regularize you.
No.
Without a direction to that effect, how can that post be blocked?
No.
You have a right to be regularized is a different thing. For that, you may have a case. But without putting that case, you see, the challenge to the advertisement is always consequential to your regularization.
Yes, Your Lordship. Then that advertisement was cancelled. So in respect of the post in question, the post held by the respondent petitioner, Your Lordship, that has been cancelled and direction has been given to regularize.
Is it given? There's a direction.
Yes.
Each 135.
Page 124.
You were appointed how?
Through a regular selection process by way of advertisement, both in local and national papers, Your Lordship.
Yeah.
But I was appointed on contract basis, Your Lordship. So
You were appointed on contract basis.
on the contract basis.
So your case now is covered by the judgment of Bhulasnath.
Not recently, but at that point in time, Your Lordship, Vinod Kumar was there. That was in January 2024. And in December 2024, Jaggu came. And Bholanath.
I think your case directly is covered by Bholanath.
Bholanath, Your Lordship.
Now, why should we interfere? Madam, it's covered by the judgment of Bholanath.
Yes, Lordship.
Bholanath, isn't it? Bholanath's judgment is those people who have been appointed on contract basis by a formal selection process and having worked for a particular period of years, they should not be terminated and they should be regularized. That's Bholanath.
Lordship.
And exactly on the point. Why you are not covered?
Yes, Lordship. But for the ends of justice, let the learned CGC may be heard for once. In that case.
And who is appearing for response number 5? Union Public Service Commission.
No, in appeal, Your Lordship, in appeal, they have not met UPSC party, with the commissioner party. But in the writ petition, I have met my party because that presentation.
I think we should dismiss your appeal. You have the judgment of Bholanath?
Lordship.
Judgments, which is going from the page, so just we should go now for something. These judgments really is covered, right?
Para 8, 11 to 14. 11 para. Para 8 are the issues. Issue 2.
Para 8 is the issues.
Issue 2 and 11 to 14. That is on finding on issue 2. And your lordship may kindly see para 10, that is just where the observation of finding of the learned single judge, para 10, which is at page 14. The learned single judge by common order dismissed a petition filed with appellant seeking a writ of mandatory respondent state to regulatory service. In doing so, the court placed reliance on the terms and conditions of
You
the
kindly
employer.
come to paragraph 11.3.
Yes,
In the present case, the appellants were appointed by the state authority against sanctioned posts
yes.
of junior engineers, with the engagement being prescribed from the inception as contractual nature. The terms and conditions governing the engagement stipulated that the appointment would be for an initial period of 1 year, extendable thereafter, subject to year. Accordingly, granted extension to the appellants from time to time until the year 2000, when it was expressly clarified that the extension being granted would be the last. It was thereafter the appellant approached the court. The consistent stand of the appellant has been that the respondent state's refusal to grant regularization is arbitrary and so and so. In so and so long clarified that fundamental right guaranteed under EA is incapable. Then the Supreme Court took into consideration Brothanath Ganguly, Pani Ram, and here, paragraph 13. This is a bit a change from what was held in Umadevi. Umadevi says that there is no legitimate expectation. How many years you are there? This is what is being changed. When employees have been continued to discharge their duties on contractual posts for a considerable length of time, as in the present case, it is natural that a legitimate expectation arises. Then Umadevi here, this is the how it is being distinguished at paragraph 13.1. Because this is what Umadevi said at paragraph 47. Now, however, this court in Umadevi clarified that the bar against invocation of the doctrine of Ivan applies only to those temporary contractual area whose engagement was not preceded by a proper selection process. In accordance with, consequently, where such engagement is made after following a due and lawful selection procedure, there is no absolute bar. What is wrong with the judgment?
What should be in any case, let the CGC be heard.
What
For that.
CCC? You are
Since I'm
there.
just a local
Where is the
location.
CCC for us today? I think we should dismiss your case.
Let it be listed next week.
Next week, the sister will pass the order. I will be sitting from there and sister will be sitting here. She will pass the order and I'll sign.
Anything up to your lordship.
This we cannot grant an adjournment because last time also you have taken adjournment.
Yes, to seek instruction.
And why the council is not coming from here? He's the council out there in Gauhati.
Yes, lordship.
Then he knows he can very well appear.
He's not in a condition to appear today. He's
Why?
at his post.
What is this leave? This type of leave he also knows. This type of leave doesn't have any well. This is done by Mr. B. Deka, CGC. There is no stay.
No.
So have you complied with the directions or not?
Yes,
No,
all
Your
of the
Honor.
instructions.
No, you have not. It's a contempt.
After filing of contempt, this appeal was filed.
Ah, I see. Anyways, I'll help it. But in the principal seat, I would have dismissed your appeal. Taking in out here. What do you say? Some more times will be granted.
But what further instructions?
Nothing. What is the instruction? It is covered by the Supreme Court judgment. Directly covered now with this latest judgment of the Supreme Court.
Yes, Lordship.
Then I think we conclude the hearing. Go to Supreme Court. Hearing concluded, judgment reserved. Or should we dictate the judgment? Finish it off. 2 minutes.
Will they engage counsel make appearance on that?
Not necessary. We don't require. None appears, we finish it. Actually, we dictate it. This is it. Heard the learned counsel appearing on behalf of the present two appeals, heard so and so and so and so. The present two appeals are directed against the common judgment and order dated 27/11/2024, passed in WPC number 38/2023 and WPC number 39/2023. We find it relevant to take note of the brief facts which led to the filing of the present appeals. Next. In the year 2006, applications were invited by the Central Institute of Horticulture for appointment as consultant on contract basis for a period not exceeding 12 months for undertaking various activities of the Central Institute of Horticulture. The consolidated pay was fixed at rupees 20,000 per month. An interview was held for selection of the consultant (technical), and after completion of the recruitment process, the petitioners in WPC number 38/2023 and WPC number 39/2023 were selected. On 9th of August 2006, the Deputy Commissioner (HOT) and OSD CIH Nagaland approved the selection of the petitioner in WPC number 39/2023. Similarly, on 4th of July 2007, the selection of the petitioner in WPC number 38/2023 was approved for appointment as consultant technical on contractual basis for a period of 1 year. The materials on record further show that the petitioners, though were initially appointed on contract basis for 1 year, but their contracts were extended several times till 2023. Their salaries were also increased from rupees 20,000 per month to rupees 25,000 per month. First, both the petitioners submitted a representation along with some other employees submitted a representation on 3/12/2020 before the additional commissioner bracket hot dash fruit bracket close Department of Agriculture, Cooperation and Farmers Welfare, Ministry of Agriculture and Farmers Welfare, Government of India, Krishi Bhavan, praying for absorption of their services as regular employees of Central Institute of Horticulture. While these representations were pending, an advertisement was issued by the Union Public Service Commission bearing advertisement number 5/2023. Mr. Jamil, what is the date?
The date is not there in the advertisement. Advertisement, your worship, it is annexed in the petition, but then date is not there.
Where?
We can see page 69. Page 69. On top only advertisement number 5/2023. Page 69.
Advertisement was issued
Advertisement number 5.
bearing advertisement number 5/2023 by the Union inviting application for filling up of various posts. In the said advertisement, more particularly, which are the two posts?
Number 2, horticulture specialist, page 70, and 3, assistant horticulture specialist.
In the said advertisement, there were two posts. Amongst the various vacancies notified in the said advertisement, it included the vacancies for the post of horticulture specialist in the Central Institute of Horticulture, Nagaland, as well as
Assistant horticulture.
two vacancies for the post of assistant horticulture specialist in Central Institute of Horticulture, Nagaland. It is the case of the petitioner that these two posts we are only concerned with assistant horticulture, na?
In one in the horticulture specialist, in first in Article 12, in Article 13, assistant horticulture specialist.
But both were appointed as consultant.
Subsequently, your worship, in Article 12, he was appointed as horticulture specialist.
One.
And yes, and your worship, so far as that consultant, technical consultant is there, as per the incumbency list, as per the recall, there is no sanctioned post of consultant technical worship. So I have been always treated as AHS, assistant horticulture specialist. So,
Was the appointment letters ever said to be that?
No, your worship. But then here, when I have challenged the advertisement, I have said that the post held by the petitioner, which is not being denied by the respondent.
Where is it mentioned? According to the CIS Mezima, by so-and-so had issued offer of appointment to the petitioner to the post of horticulture specialist.
That is read April 12.
So you were again appointed. Earlier in 2007, there was an appointment.
As technical consultant, thereafter appointed as horticulture specialist.
Okay. These have not been taken care of. Madam, you just write out here, after this, after you have written, similarly on 4th of July 2007, I have said, the petitioner in WPC number 38/2023 was approved for appointment as consultant technical on contractual basis for a period of 1 year. Okay? Then thereafter, I have said, salary have increased in the meantime. Then you write. It is also seen that pursuant thereto, an advertisement was issued by the Center of Horticulture, Mezima, on 27/1/2016, inviting application for one post of horticulture specialist and one post of assistant horticulture specialist on contractual basis for a period of 6 months in the office of the director, CIH, Mezima, Nagaland. In response to the advertisement, against this advertisement, both the petitioners applied.
Yes, for horticulture specialist, but only the petitioner, only one was horticulture specialist, because both were serving as consultant technical. So
Understood. So one petitioner got horticulture specialist, the other got the assistant.
No, there was only one post of horticulture specialist, your worship.
Now, who got the horticulture specialist? Okay. It further appears that pursuant to the said advertisement, an interview was held on 23/2/2016, conducted by the selection committee headed by the director, CIH, Mezima. Pusto.
Page
The
61.
petitioner in WPC number 39/2023 was selected for the post of horticulture specialist.
Page 61. And petitioner.
And an order was passed, and an appointment order was passed on 9/3/2016 to the petitioner in WPC number 38/2023 to the post of horticulture specialist. Post. And the other one?
The other detective, 13.
Did he get any assistant horticulture?
No, he was appointed as consultant technical, your worship.
And he continued as such.
He has continued, but he has always, there was no post of consultant technical, so he was always treated as AHS. Your section.
Okay. It is further seen from the materials on record, more particularly the contents of WPC number 38/2023 that the petitioner therein continued to remain as a technical consultant.
Consultant, we didn't break it, technical.
With the Center for CI, Center for Horticulture, in the centers.
Central Institute of Horticulture.
Horticulture. Pustak. And Pustak. Pustak. It further appears that the services that though the petitioner in WPC number 38 of 2023 was appointed as a consultant technical, but he was carrying out the work of assistant horticulture specialist.
Your Worship, read Article 13, page 59. That is the incumbency list, where I'm shown as AHS.
And this aspect is apparent.
Page 59. Read Article 13.
From the very
The incumbency list, detail of sanction.
from the details of the sanction post oblique incumbency list
Serial number 5.
issued by the Central Institute of Horticulture, issued by the Director in charge Central Institute of Horticulture, dated 27/1/2023, Annexure 5 to WPC number 38 of 2023, wherein the said petitioner has been shown as the assistant horticulture specialist. This court also finds it relevant to take note of. It finds also relevant that a further perusal of the said communication dated 27/1/2023 reveals that both the petitioners in WPC number 38 of 2023 and WPC number 39 of 2023 were shown as being appointed against sanctioned posts. It further appears that the petitioners, in the meantime, had submitted a representation along with others. Petitioners in both the writ petitions, in the meantime, submitted a representation along with others on 3/12/2020 for regularization of their services. However, the said representation submitted by the petitioners in both the writ petitions were not considered. And on the other hand, the Union Public Service Commission has issued an advertisement number 5/2023. The said advertisement is Annexure Roman 3 to the affidavit in opposition filed by the respondent numbers 1 to 4 in WPC number 39 of 2023. A perusal of the said advertisement reveals that one post of horticulture specialist and two posts of assistant horticulture specialist were also advertised. Two posts of horticulture here in the Central Institute of Horticulture, Nagaland, were advertised. The petitioners, being aggrieved that there were not being considered for regularization, and on the other hand, and not considered for regularization, after having worked in the Central Institute of Horticulture for the last
More than 15 years.
16 years. And on the other hand, the post where they were working were being advertised, approached this court by filing the writ petition, filing two writ petitions, being WPC number 38/2023 and 39/2023. The records further revealed that the respondents numbers 1 to 4, who are the appellants herein, have duly admitted that the petitioners were appointed initially as technical consultants.
Consultant within bracket technical.
Pursuant to a selection process
By way of advertisements, both in local and national level.
and further, that the petitioner in WPC number 39/2023 was also appointed as a horticulture specialist pursuant to a selection process. It was also admitted that the petitioner in WPC number 39/2023 was allowed, was shown again, the appointment of the petitioner, appointment of both the petitioners was shown against sanctioned posts. However, the specific stand of the respondent numbers 1 to 4, and more particularly 1 to 4, that is oblique the appellants herein, was that the petitioners in both the writ petitions were appointed on contract basis. And therefore, there was a requirement that they should, and therefore, on the basis, on a contract, was appointed on contract basis. And therefore, it was as appointments to the post of horticulture specialist and assistant horticulture specialist are to be done by way of an advertisement to be issued by the UPSC as per the recruitment rules. The question of considering the case of the petitioners for regularization did not arise. The EPSC, who was made a party in the said proceedings, in the writ proceedings, also submitted an affidavit stating inter alia that they were taking steps as per the request made by the respondent numbers 1 to 4. The learned single judge, by the impugned judgment and order, came to a categorical finding that after having permitted the petitioners to work for 16/17 years and not regularizing them, and on the other hand, their post being advertised, was absolutely arbitrary and unfair and violated the mandate of Article 14 of the Constitution. Paragraph number 26 and 27 of the judgment of the learned single judge is reproduced hereunder. Next. On the basis of the above reasoning, the learned single judge directed the respondent numbers 1 to 4, who are the appellants herein, to regularize the services of both the petitioners from the date of their initial appointment and further quash the advertisement number 5/2023, whereby applications were invited for filling up the vacancy numbers 230-3050-3311 and 230-3050-2311. The learned single judge further made it clear that the respondent UPSC would be at liberty to start the procedure of recruitment for the other posts. Being aggrieved, the present appeal has, both these appeals have been filed by the respondent numbers, by the appellants herein, who were the respondent numbers 1 to 4. We have heard the learned counsels appearing on behalf of the parties and have perused the materials on record. From the materials on record, it appears that pursuant to an advertisement dated 11/5/2006, issued by the officer on special duty of the Central Institute of Horticulture, both the writ petitioners in the two writ petitions were appointed
Lordship, by different advertisement. But here, this is in respect of writ appeal 12. In writ appeal 13, but it is not disputed that both of them were appointed through a regularization process.
That's a different advertisement. When were the other one appointed?
This is 2006. Advertisement 1. But both were appointed by way of advertisement, both in writ appeal 13, Your Lordship. Page 43, there is the statement which I've made. Para 3. And the advertisement, Your Lordship, I could not obtain, but it is reflected in the noting nature 1, page 55. Page 55. This is the proceedings. This is regarding engagement of one number of consultants for CSS based on approval of complaint application were invited for engagement. Application website.
No, tell me when were the people appointed first?
One is appointed in 2000. Consultant in April 12. The petitioner was appointed in 2006.
No, what is the date?
May. 11 May. No. No, not that. Page 60, Your Worship. Irrevocable. 12. 9 August 2006. A casing as consultant technical. Lordship has got it, page 60. 60. And to conduct the approval of the complaint authority in this department for engagement of street casing as consultant within bracket technical. It is 9 August 2006.
Advertisement is page 55, isn't it? 55 in written.
Page 56. Page 56. Next repetition. Read April 13. Is the appointment order for July 2007. One in 2006, the other one is in 2007.
But tell me one thing.
Lordship.
When were you appointed against the sanction post?
In fact, Your Lordship.
It is only in that letter of 2023. It is being shown.
Horticulture specialist, Your Lordship, that is the sanction post.
No. You were never appointed as a horticulture against the sanction post.
In 39, in Article 12, Your Lordship, initially my appointment was consultant technical. Thereafter, again, advertisement was issued. And Your Lordship, I kindly appreciate also for the post of assistant horticulture specialist and consultant technical, Your Lordship, as per the RR also, educational qualification, everything are same.
No,
both the petition.
no, Mr. Jamil, that is not the question.
Page 61 is the interview for horticulture specialist.
The word in 76 snakes was born. You make up something here, something's missing. So therefore you have taken in the year 2006. Moment it was there, then there were 19 points. Here, the common see we are going to give them 19 points of compensation. Maybe.
Lordship, I kindly see page 61. That is the interview for the post of horticulture specialist.
No. This is 2006. Between 2006. And contract would be appealed. The areas still not there. 17 possible effective which is so there was an advertisement there of 17 posts regulated. Then see, since then, in 2009, each post of the period, so these distributions, the enforcement. However, the requirements solutions say they need to be like the 16. So these posts will not be, they will not there. If you like, we have some particular condition. These posts will be paid at once. And we had different method would be that's as per the direction of the department was functional. It's just right. And they put management
Lordship, I kindly see page 61. That is the interview for the post of horticulture specialist.
No, this is okay. I'm not on that. I'm not on this aspect, but here you kindly see. The affidavit which has been filed by the respondents. We find that the learned single judge have not taken a very important aspect. Kindly see paragraph 3 of the affidavit, page 88. That at the outset, the answering opponent states that the Central Institute of Horticulture was established on 16/1/2006. So therefore, this aspect assumes relevance, taking into account that that advertisement which was issued is of the year 2006. Okay. It was proposed to engage consultant technical on monthly contract basis for a period of 1 year to take up the various development activities of the institute till the appointment of regular staff. With the approval of the ministry after conducting interview by the temporary committee members, 4 numbers of candidates were engaged as consultants. I think amongst the 4, these 2 persons are there.
Lordship.
So therefore, it was in pursuance to an advertisement issued in the year 2006.
Lordship.
And they were appointed in year 2007.
2006 and 7.
But here it says only 2006. Or
It says
they were engaged as consultant Nagaland in 2007.
One in 2006.
Where is your appointment in
And
2006?
Taking your worship to the appointment order, 9 August 2006.
Where?
In Recapitule 12.
Huh? 12. Page?
Page 60. I've read out what's your worship. If I am the agency.
So this is in pursuance to advertisement dated?
Your worship, it may kindly come to page 58. This is the type copy. Based on second part, based on the approval of complimentary applications for invited for engagement of successes in 3 to advertisement in 3 leading newspapers and 1 national newspaper. We have received 33 applications.
So how many people were at all appointed initially? 4.
Initially, your worship, the recommendations are there.
Here, why they are saying here recommendation is again another one? It is different. Here
It is
say
regarding horticulture specialist.
we received 33 applications, the details of which 30 were received by so and so, the applications of so and so were received. So this happened on this. Then the appointment comes on 9th of August in 2006. And what about the other one? Why he was appointed subsequently?
Subsequently, there was a different advertisement in the next recapitule, page number 56.
What is the date of that advertisement?
The appointment order, your worship,
Hmm.
upon 4th July 2007. Page 56.
No. What is the? Let's see an actual.
And these are the minutes, your worship, page 55. Second para. Based on the approval of combinatory application, were invited for engagement of a consultant technical to advertisement in 3 leading newspapers in North East Region and 2 national papers, your worship. And the name of the petitioner is serial number 3. I've been seeing based on that is the recommendation selection of CISS.
But from this document at page 96, it appears that the director at page 96, it appears that this is the Ministry of Finance, the proposal for the Department of Area for creation of 48 posts for setting up the Iman has been considered and it has been decided to agree to the creation of the 17 posts. Here we don't have consultant, technical.
No consultant. And even look at the incumbency list, there is no post of saints.
No, I'm not on that. Page 96 does not show a post of consultant technical. Okay. So therefore, their appointment was not against the sanctioned post.
That is my case. Because though I was appointed as consultant technical, your worship, I have been always shown as AHS.
That was shown only later on.
Yes.
In the year 2023.
But then since then, I've been continuing by the AHS. I've been treated as assistant horticulture specialist, your worship. But horticulture was, the first read April 12 is concerned, Your Worship, in 2016, through advertisement again, as I just continued from, I was appointed as horticulture specialist.
No, understood, but late, understood. For one person in the year 2016, he was appointed against as a horticulture specialist.
That is the sanction.
That is a sanction post. That is in 2016 against a sanction post. But that only is 7 years.
No, but Your Worship, I've been all since day one, Your Worship.
But you were not appointed against the sanction post. And the second petitioner was never appointed against the sanction post.
There was a sanction post of assistant horticulture specialist, Your Worship, but for reason best known to the respondent. Instead of advertising, even educational qualifications are the same, reputed as per RR. But instead of advertising the post of AHS, they have advertised the post of consultant technical, and I have been met to discharge the function responsibilities of AHS. That was my case. Advertisement was made both in national, local and national purpose against a post which is not in existence as consultant technical.
No, understood.
Yeah.
But it's not a sanction post.
Yes, but I have been made. I have been made to discharge.
Then why did you appear for an interview in 2016?
Your Worship.
Why did you appear in the year 2016 against horticultural specialist? You were a technical consultant.
Because the educational, actually, as per the RR, horticulture specialist is a promotional post. As
From?
per the RR, from AHS, assistant horticulture specialist.
No, understood. So therefore, why did you appear if you were a technical consultant? Your appointment was a consultant technical, which is not a sanction post.
Roshi.
So this very aspect, having not been taken into consideration by the learned single judge.
No, but Roshi, posts were advertised. So accordingly, I have been paid for this.
Understood? No. You see, there is a question. You can very well appear out there, apply, and your service, because at that point of time, another very important aspect happens that after your appointments were made, they say out here that accordingly, recruitment rules for 17 were notified, and after that, many attempts were making several attempts, no post except the post of director could be filled up.
Your Worship, there are two reasons. They're relying on RR 2022, but RR 2007 was there.
It's okay. There will be a RR 2007.
Yes.
Now, at that point of time, did they initiate any advertisement for these posts?
That is the thing.
They say they have done so.
Because when you were appointed, there was no sanction post.
No, there was sanction post, 17 sanction posts were there. 17 sanction posts were there.
Understood, but not the post of technical.
Lordship, that is my grievance was that. There was a sanction post of assistant horticulture specialist. They could have engaged me, issued advertisement for the post of assistant horticulture specialist on regular scale pay, on regular basis. But instead of doing that, they come up with a novel method. They have engaged, they have issued advertisement for a post of consultant technical, which is not existent on contract basis, but we have been made to work to discharge the responsibility of assistant horticulture specialist. So the action of the respondent is questionable. That was my case. What prevented them? One was the sanction post of assistant horticulture specialist, Your Worship. What prevented them from advertising the said post on regular basis? But
no, there was an advertisement at that point of time. That is what they say.
yes,
They could not fill up. And now the government says, they say out here that look here, now the Department of Finance says, okay, we will permit it, provided you fill it up by regular methods. This is what they say, Annexion 9. Accordingly, 9 of all 16 posts were notified with the inclusion of the direct recruitment method to recruit so and so.
They are trying to justify the action, the legal action, by filing affidavit. By way of filing that affidavit, Your Lordship, they are trying to justify the cure the illegal action, the arbitrary action.
But Mr. I think this is a case for admission.
Instead of waiting till
Not to
2020.
be dismissed like this.
Instead of waiting till 2023 for issuing the advertisement, Your Lordship, I have been met to. So for now, I am on the verge of attaining the age of superannuation. I have 4 or 5 years hardly, Your Lordship. Now, at this stage, issuing that advertisement.
Are you going to give up after 4 years?
But I'll be attaining the age of superannuation.
Now tell me, we have another big problem with that order. Your seniority is to be counted from that period. From the date you have been appointed in 2006.
Yes.
Why? That is against some other post. You became a horticulture specialist in the year 2016.
Lordship.
And 2020, in 16, in 4 years, you file a representation that look here, give bid to me. Regularize my services.
Now, Your Lordship, may I take Your Lordship to page 62?
Yes. Yes.
This is regarding enhancement of unity and industrial street encasing and fencing technical consultant, whatever. Now. Para 2, Your Lordship. In view of the above, it is clarified to say that these 2 persons will be entitled to be enhanced superannuation such and such.
Page?
Page 62 of.
Page 62.
Of read appeal number?
Read the appeal number. Read the appeal number. Your Lordship, tag copy is in the next readable token. Tag copy.
What is that? This one, page 63, Annex 7.
Yes.
No.
Second para.
Page 62 type copy.
62 tag copy.
Read appeal 13.
What is that document you are mentioning?
This is a letter from the Ministry of Agriculture.
Read appeal 13.
Now the petitioner responded, they have submitted the representation for enhancement of remuneration. Lordship as for
Yes.
page 62. The relevant para 2. In view of the above, it is clarified to CS Nagaland that these 2 persons will be entitled to enhance remuneration for the post of technical consultant judges such and such as indicated in ministry order number such and such, and will continue to be designated as technical consultant till their engagement in CS or their adjustment against the post of horticulture specialist person.
Till the engagement in CS or the adjustment against the post of year. So at that point of time, they are not adjusted.
No. Now the vacant post is there. I am now holding the post in Schedule 12. I am holding the post of assistant horticulture specialist, Your Lordship. At least legitimate expectation is there, Your Lordship. Like that, at least I should be adjusted.
But you only for 4 years. You became horticulture specialist in 4 years. That means you were adjusted. You were not adjusted. They initiated an advertisement of 2000 only in 2016, where both of you, not he, she, but both the petitioner were participants,
Lordship,
of which one got it. The other was in the waiting list.
Lordship,
So the person who got it, he only got it in 2016.
Lordship.
So initially, they were not against the sanction post.
No, that's the sanction as from day one.
No, the sanction is there at the annexure 1 to the affidavit filed by the respondent numbers 1 to 4. And you see page 96 of writ appeal number 12.
By this, Your Lordship, the earlier abolition of sanction post, it was revoked.
No. You have to understand, CIH was formed in the year 2006. At that point of time, this was the document by which these 17 posts were created. Amongst these 17 posts, there is no post of technical consultant.
Agree.
However, in the year 2006 and 2007, there were certain advertisements issued for filling it up, of which one petitioner was appointed in the month of August 2006, and the other petitioner was appointed in the February to July 2007. So these are the two persons who have been appointed. Of which one petitioner, both these petitioners thereupon, see an advertisement issued in the year 2016. Now, this is against the sanction post.
Yes.
This particular sanction post, against this sanction post, both the petitioners apply, of which one gets appointed, other continues as a technical consultant. In 2016, he is now for the first time brought within the purview of a sanction post.
Your Lordship, in my respectful submission, Central Institute of Horticulture cannot run in absence of assistant horticulture specialists and horticulture specialists. It was there since its inception, Your Lordship. Now, they have issued an advertisement for a post of horticulture specialist where we have participated in 2016, Your Lordship. In fact, since inception, because it is Central Institute of Horticulture. Without assistant horticulture specialists and horticulture specialists, how just consultant technical can manage it? No, Your Lordship. It was set up in 2006. The post family is there, Your Lordship. And my goodness, before the report was there, when the post was there, assistant horticulture specialist, they could have filled the post on regular basis paying a scale of pay. But instead of doing that, they resorted to a novel method. They have issued advertisements.
So, Mr. Jamie, your submission is a rose in whatever name you say. So, therefore, you may call it a technical consultant or whatever it may be, it is actually the post of assistant horticulture.
Their own documents. I'm not saying their own documents.
The document only comes in the year 2023.
But then, even in 2023, I am shown as, though I am serving as technical consultant, I am shown as AHS in 2003 also. When the post was not there at all, what is the point?
But we can't give you this regularization for the purpose from initial visit. That is a very difficult thing. Because they will change everything. You may be regularized. But only that period can be used only for the purpose of what else? What did this court do? Let us see.
Since initial appointment, that is longer than.
No, in this judgment.
Serious benefits on the date of completion.
Shall be entitled to consequential service benefits accruing from the date of discharge. That is what we can. And that will she get something.
No.
But I think we need to redraw the judgment properly, taking into account many things the learned single judge has not taken. With due respect. The single judge has not taken what is the actual contention. The actual contention is, you see, the thing is like this, if we don't draw up the judgment taking into account their stand properly, the problem which will happen is, they will go, this union will go to the Supreme Court. Once they go to the Supreme Court, it becomes very difficult for you to sustain this judgment. You see, what did the learned single judge say? The learned single judge says, look here, they didn't say anything. They admitted everything. Except their only contention is that this should be contract.
As per Arab and Umani.
So therefore it is required. The learned single judge went into the question of 14 that they have been working for 16, 17 years. But actually, if you see, you have worked for 4 years when you submitted a representation as a horticulture specialist. And the other person has not been there. But there needs to be a justification given as to why they did not call for a technical consult. They used the name of a technical consultant, but it was actually an assistant horticulture, which is apparent from 27/1/2023, because that was the post which was sanctioned. So in fact, you were appointed as a sanctioned post. This is a justification which is required to be given in order to support this judgment. Don't you think? Chalo. And I think we need to give 2 judgments.
Okay.
The reason of one judgment, the problem of it can be done, but it will be the facts have to be properly resolved. Because here, the learned single judge did not look into those aspects. It went just for it even didn't go to the question of horticulture. You are appointed, one of them has been appointed as a horticulture specialist.
Right.
It went into, it was proceeding as a technical consultant. Isn't it?
As per the order, yours. Otherwise, everything was before the writ court.
Understood.
In fact, even pleading also, in my pleading.
I've seen it.
Even in the.
So initially, therefore, while I was dictating, I went into that, seeing the judgment. Then I found that no, there's a difference between the two.
Yes.
Now, after seeing the moment I asked for you the advertisement, then I see the affidavit, it gives another tangent, which has not been taken into consideration by the learned single judge. But I think anyways, what order has been given, maybe the conclusion appears to be right. But not from the initial basis. The service benefits only can be given from the date. We cannot give you from that. Let her also be your son. I am very happy.
It can only be. What can we get?
Absolutely. So as per this, I think we'll make it CAB because I have a single bench also.
Okay.
CAB. And this is the order, madam. We interfere only to that extent that the benefit would be only from the date of the judgment, not prior to this. So not from the initial, because initially if you give it, then he will be entitled for many other things. The various service benefits will be there from the initial plan. But he will.
Proceed in this case, if I can be allowed to submit the instruction with the procedures.
Madam, we understand this, and we have I'm also of your opinion. We should not, taking into account Umade. But the problem arises with the two recent judgments. One is Bholanath and Dharam Singh. This Bholanath judgment, which is now holding the field,
Yes.
and whereby here you say that there was no advertisement as per the RRs. But the fact remains that there was an advertisement. The fact remains that the department, the ministry was well aware that these people were appointed as technical consultants. They, more particularly the document, the 2011 document, they were well aware that they were appointed as technical consultants. And they also say, to the extent that if they are not adjusted as horticulture specialists. In the year 2000, you were using all these people as the technical consultants. All along. And it is not that you bring somebody out from somewhere. This is in pursuance to an advertisement, proper advertisement. And it is not that without an advertisement you have done. Yes, it should have been done by the UPSC. But the fact remains that there were attempts also being made, as being seen from your own affidavit. But no one came. Except the post of director was filled up. So therefore you were running the CIS, taking them. And after taking 16 years of service or 17 years of service, now you're saying that these people cannot be, let them come. Then how do we take care of Bholanath? That is the problem. So we only will interfere to the effect that it cannot be given from the original batch. We'll duly consider this aspect which is there. Consider and pass the check. Hearing complete.
You'll be all right.
Please, my lord, item 20 in the supplementary list. This item was listed on Tuesday, but the item did not reach, so Lordship has started to give the dates for mentioning due to some communication gap with my juniors. It was fixed today, and accordingly, I also made plans for journey in the second half. So considering the time factor, it is not likely to reach. So Lordship may kindly accommodate me for today.
Okay. When do you want it?
Lordship.
Next week? 19 and 20 next. At the request of Mr. C.T. Jami.
May I please worship, my lord, I pick commission item number 5 on behalf of AIME, my lord. My lord, I'm informed that she is not feeling well. So kindly list the matter next week, my lord.
5 next week at the request of Mr. Smith.
Much better.
From the supplementary cost list for motion, item number 18.
Yes, what is this case?
May I please, Lord? But the decision is agreed by the promotion, regularization of the promotion of private respondent number 4 by order dated 9 March 2026. This private respondent number 4 and the petitioner, they were recruited in 1996 in the same year on the basis of an advertisement. The petitioner was appointed as assistant research officer and she was appointed in the general cadre. However,
Where's the appointment letter?
appointment letter is page 21.
Why are so many judgments here?
Lordship, in short, I will take about 6-7 minutes. The private respondent was all along upgraded to the higher post personal to the incumbent. As many as 5 upgradations were made, personal to the incumbent. After reaching the post of additional secretary, she was brought to the cadre. So, few petitioners have challenged who are in the zone of consideration in the general cadre that look, you cannot come by shortcut because you belong to X cadre. Without amending the rule, you cannot come. So, the writ petition was allowed, quashing the engagement. Now, after deciding that case, within 6 days, the rule was amended in the supersonic speed. And after amendment of the rule, it was on 18 May 2022. Rule was amended. After about few days, her appointment order to the post of additional secretary was cancelled by the speaker. Thereafter, the amendment of the rule was challenged by the association, but that was dismissed on the ground of technicalities and on consideration of convenience. That is one litigation. Side by side, thereafter, the private respondent was given temporary officiating charge to hold the post of secretary. Since that was challenged by the present petitioner on the ground that look, even for temporary charge, the seniority should not be ignored, she should not be given. But then that was also at the time of motion, interim was granted, but by filing an IA, the interim order was vacated. Against the vacation of the IA, the petitioner again filed a writ appeal, challenging the vacation order. But ultimately, that was also dismissed. However, an observation was made by the division bench that let the post of secretary may be filled up without further delay in accordance with rules. That was the observation by the division bench. Lordship will find at page 136 that observation. Page 137. As your lordship read it, on the top, 3 lines. However, we are of the considered view that there should be no further delay in filling up the post of secretary NLA on regular basis in accordance with law. So, post has to be filled up in accordance with law. This order was passed on 22nd July 2022. And they have not taken any steps. Suddenly, this Indian order has been passed by regularizing the
Where?
officially promotion.
Where,
Now,
this one, page 141.
141. In continuation of this secretariat order number so and so,
This
5th
is
July,
being done by regularizing.
it was regularized without any promotion. So, 5th July 2022 order, kindly come to page 100.
You-
This, by this order, she was delegated to temporary officiating charge of the secretary.
Okay, what is the rules? Let's see the rules.
Rules, there are only 3 methods of recruitment.
Where's the
Under
rule?
Rule 9,
Page,
page 142, relevant portion, Rule 9, method of recruitment. Page 145.
now, where is the rule for secretary? Promotion.
Lordship will come to the schedule. Page 158. Page 158. Column number 5, method of recruitment by promotion, by invitation. And then in column 6, qualification is mentioned. And the grade from which the promotion is to be made.
By promotion by deputation.
Yes. And then Rule 15 provides for constitution of TBC. Because any promotion can be considered by the TBC. But simply by this order.
So you say that this is not a case of deputation,
Yes,
so it is a case of promotion.
yes,
If it is a promotion, then there has to be by way of a selection.
correct, Lordship.
And without a selection, you cannot regularize.
Yes,
And more particularly when the learned division bench has particularly mentioned
yes,
that to fill up the post of secretary
exactly.
by way of a selection process.
Yes,
That's your case.
yes, Lordship.
Who is appearing for response number?
I am preparing for response number 1, Your Worship.
Private respondent.
Lordship, I am especially for appear for the great response. They have received.
You are on caveat?
No, so one of the. No, sir.
Which state? Because this is, you cannot, we would not stop you from filling it up by following the mandate of the rules, but you cannot have it by way of a regularizing. And because this goes against the order passed by the learned division bench.
One of the, let me receive, no, let us receive instruction because we have not seen what is contention, so it's not that you give it to us.
No problem. No problem, but we stay this because if we don't stay, it will have far-reaching
One
consequences.
of the, let the interim order on question and interim will be heard on Monday.
Monday.
Because.
Monday, Your
Like,
Because
Your lordship, the problem is now session is going on.
Yes.
So,
Session is going on, assembly session is going on. And they all are busy in discharging your responsibility as secretary, Johnson.
she will remain as an officiating.
Yes.
That is the point, Lordship.
No, she is already an officiating secretary.
Yes, for the last 2 years.
Manoj,
On Monday.
No, my question
because
is,
we would like to see the reports, how she was.
no, you are not on KBF, Mr. Takalas.
Yes.
So the question is, she is already an officiating secretary.
Good lordship.
So if she is an officiating secretary, this post out here, regularizing, you can't regularize. You can select and appoint her, but she remains as an officiating secretary.
Yeah, your lordship.
If we stay this, what is the effect?
No.
The problem is this, your lordship, now, whether any selection process has been done as per the rules as directed by the, as per direction of, as per the Honorable Division Bench, your lordship, whether any process was initiated, I am not aware of, your lordship. That is why, if interim be considered on Monday, it is a small matter of 3 days only, your lordship. No prejudice will be caused to the petitioner.
Lordship, rules have been given a go by.
I will just produce a record, your lordship. If any selection process, no selection process is done, then I'll leave it to your court, to the court, your lordship. Monday, interim, the court is a matter of 3 days only, your lordship.
Even if the regularization order is suspended, still, she's discharging us the officiating, on officiating basis. That was the practice for the last more than 2 years. She was holding the charge of secretary on officiating basis. There was no difficulty, no problem. So even if it is suspended also, that is only with regard to the regularization. Therefore, she will function as the secretary on officiating basis as per the order. But rules have been given a go by.
Lordship may direct me to produce a record Monday, that is.
Since it is in totally violation of the rules, Lordship may kindly consider for suspension of regular order. And by doing that, also they are not adversely affected. I'm also not adversely affected. My rights will be affected. Because it is a promotion. Kindly Lordship see one order. Her temporary officiating basis is at page 100. 5/7/2022. No scale is mentioned here. No pay scale. Because she has been given only temporary charge. And kindly come to page 24. Her first.
So this temporary officiating was initially stayed,
Yes,
then it was vacated,
yes,
you filed an appeal.
yes.
After that appeal, the court said that whatever may be, we are not interfering with the vacation. However, we make it clear that this, the government needs to carry out the selection to have a permanent secretary out there. Now, in pursuance to that, they regularize the officiating persons without carrying out selections.
Yes.
That I understand. But what happens to it fall if we have it on Monday?
Produce a record.
Lordship,
Because you see, if I state also, she remains as a secretary.
on officiating basis.
So it makes no sense.
But when something is not done in accordance with law,
Absolutely
then
wrong.
definitely the Honorable Court has to examine that.
This court can not only set aside. This is a case for setting aside on the first day itself. Let him produce the reports and not that. If I was there on Monday, I would have set aside with the records. You should have moved it on Monday, last Monday. By today, it would have been finished. Anyways, let's have it that the notice returnable on Monday. We note Mr. Takamasa is appearing. On behalf of BI, you will serve an extra copy. You will file his affidavit by Monday.
In fact, as per the record, if no selection done that Monday, it can be disposed of.
What do you say, Mr. Jamil? I was waiting. Since last 2 weeks, there is no motion. There's so much of disposal out here going on, and there's no motion. So I thought that something is there. You should have moved it on Monday.
Lordship, they're finding up the division page.
I
Where
understand.
the president
Mr.
view-
Jamil, you have, I'll note that in my order. Issue notice making it returnable on Monday. Huh? 30th. Mr. T.B. Jamil. The learned counsel accepts notice on behalf of the respondent number 1
1 and 3.
and 3. 2? 2 also you have to accept. No. No.
Okay, Lordship.
Officially, you have to accept 1, 2, and 3. 1, 2, and 3. Mr. Takamasa, the learned senior counsel, which your junior? Mr. So-and-so accepts notice on behalf of the respondent number 4. Extra copies of the writ petition be served upon the learned counsels appearing on behalf of the respondents during the course of the day. The petitioner herein have assailed the petitioner herein have assailed the appointment of the regularization of the respondent number 4 to the post of Secretary, Nagaland Legislative Assembly Secretariat by the notification dated 9/3/2026. It is the case of the petitioner that the respondent number 4 was appointed on officiating basis as the secretary to the Nagaland Legislative Assembly Secretariat by an order dated 5/7/2022. The petitioner, being aggrieved by the order dated 5/7/2022, approached this court by filing a writ petition being WPC number 144/2022. The learned coordinate bench of this court, by an order dated 12/8/2022 stayed, na?
12/8 is vacation order, Lordship.
Okay, by an order dated,
101.
by an order dated
22/7/2022.
22/7/2022. State the order dated 5/7/2022, whereby the respondent number 4 was given the officiating charge of the post of the secretary of the Nagaland Legislative Assembly. This order dated 22/7/2022 was vacated by the learned coordinate bench by an order dated 12/8/2022 passed in IA Civil 116/2022. The petitioner thereupon being aggrieved by the vacation of the order dated 22/7/2022 by the order dated 12/8/2022 passed in WPC number 144/2022. approached the learned division bench of this court in writ appeal number 28/2022. The learned division bench, by an order dated 3/9/2024, disposed of the said writ appeal without interfering with the order dated 12/8/2022 passed in IA number 116/2022, arising out of WPC number 144/2022. However, it was observed that paragraph number 16 of the said order dated judgment and order dated 3/9/2024 by the learned division bench as hereinunder, page 136, madam. Next. It is the case of the petitioner that the learned division bench of this court had observed that there was a requirement for filling up the post of the secretary of the Nagaland Legislative Assembly on regular basis in accordance with law. First, the learned senior counsel appearing on behalf of the petitioner drew the attention of this court to the Nagaland Legislative Assembly Secretariat bracket Recruitment and Conditions of Service Rules 1999 as amended up to date, and drew the attention of this court to Rule 9 of the said rules of 1999, and submitted that the method of recruitment to a post is either by way of promotion or by deputation or by direct recruitment. The learned counsel further, referring to the third schedule to the rules of 1999, submitted that the method of recruitment for the post of secretary of the Nagaland Legislative Assembly is either by promotion or by deputation. It is the specific case of the petitioner that the respondent authorities, more particularly the respondent number 1 and 1, have not initiated any selection process, and by the impugned order dated 9/3/2026, regularized the officiating appointment of the respondent number 4 as secretary of the Nagaland Legislative Assembly, which is not permissible as per the rules of 1999, as well as the observations made by the learned division bench in the judgment and order dated 3/9/2024 in writ appeal number so-and-so, 28/2022. First, Mr. T.B. Jamir, who appears on behalf of the respondent numbers 1, 2, and 3, submits that he would like to obtain instructions as to whether the impugned order dated 9/3/2026 was preceded by any selection process.
Or done in accordance with law, because they have all the records with them. Now, we don't know what process was adopted, but whether it was done in accordance with law or not. So whether the service role has been ignored for, that will be released.
Mr. C.T. Jamil, Mr. T.B. Jamil never said that, na? This is his submission I am recording. He submitted that he would produce the records on the next returnable date. Mr. Takamasa, the learned senior counsel who appears on behalf of the respondent number 4, submits that he had just received a copy of the petition and he would like to make his all submissions on the returnable date. Taking into account the above, This court therefore fixes the matter on 30/3/2024-26, on which date this court would duly consider as to whether any interim directions are to be passed in the instant proceedings. First, the respondent, Mr. T.B. Jeremy, the learned counsel appearing on behalf of the respondent numbers 1, 2, and 3 are directed to produce the records. First, it is further observed that if the records are not produced, this court shall consider passing of interim directions on the basis of the materials which is presently available.
For admission, item number 1.
Thanks, Your Lordship. Lordship, I'm appearing on behalf of my senior.
What do you want? Adjournment.
Yes, Your Lordship.
Why?
Affidavit in opposition has been received from the respondent number 2. However, my senior has sought instruction from the chief engineer and the ministry, and the reply has yet to be received. So meantime, the last 3 weeks time.
Affidavit in opposition filed 3 years back.
Your Lordship, we have received last year.
It is seen that the affidavit in opposition has been filed by the respondents on 22/5/2023. No affidavit in reply thereagainst have been filed. Taking into account the above, list this matter for hearing on 21/4/2026.
Actually, I'm from respondent number 1.
Who are you?
Sharif Ahmed, I'm from respondent number 1.
Very well. Your names?
For admission, item number 2.
Thank you, Your Lordship. My senior solicitor is waiting for adjournment, so the matter will come up after a week.
Which one? Oh, this matter. Next week.
Yes, Lordship.
Counsel appearing on behalf of the petitioner seeks for an accommodation. We fix it for hearing. Affidavit file. The record, no. It is seen that the records that the affidavit in opposition has been filed by this respondent on 28/11/2025. And the counsel appearing on behalf of the petitioner have already submitted on 17/3/2026 that the petitioner would not file any reply. So considering the fact that the pleadings are duly complete, list the matter for hearing on 28/4/2026.
For admission,
You just put it like taking into account the writ petition stands admitted and listed for hearing on so and so. In the earlier order also you put it, the writ petition is admitted and fix it for you. And it won't come for admission.
for admission, item number 3.
Well, I think this matter, the records are called, the records are confirmed.
What records?
Records are roll code.
Huh?
The records are roll code, just call for value submitted.
What are you challenging, Mr.?
Your Lordship, I moved an application the order level 2014 year for production of documents by Regularization.
That's a word, on the last week, this order could have passed an order, summoning the lower court record here also.
What record is this?
Yes, because.
What order you are challenging?
Yeah, I am challenging your, the order you are actually whereby, by application under order, your group 12.14 was rejected here, by a trial court here.
But how can you file a 226?
That's the only way out for us, right?
Why?
Revision is not better, your revision rights are like,
This is filed under 227.
yes, sir.
What is the order which has been passed?
Order was, your order has been passed here. It is,
Why it is being listed as a repetition?
it was 2 to 7 years. Yes.
Say, let us see what the order passed. You filed an application under order
Yes, sir.
11, rule 12 and 14.
Okay. Yes.
Then
Because
order 12, order 11, rule 12 is what?
it is for seeking production of documents, where a document which is not there, which is the custody, that should be provision. Yes. And in that matter, you are asking, the provision is that the affidavit has to be formed by order in rule 13, the specified affidavit has to be formed. That has not been filed by the respondent here.
Then
Because without that affidavit, you will be.
where is the order? Let us see.
Order is here, your order starts at page 52, your order.
60,
Page 50. Page 50.
62.
Page 52, your order.
Page?
52.
Yes.
This order proposed, my lord,
Let's see your application.
application is here. The page, your lordship, 31. 31. No, your lordship is not that. It's the application, sorry. Application is not 30, that's other. It is at page 38, your lordship, sorry. Page 30. Page 30. Lecture P3 here.
Okay. Now, Mr. Chaudhary,
Yes, sir.
where is the plaint? What are the issues framed?
Reading is not here.
Why the issues, what are the issues framed? And why do you need the records?
Records, because the court want to see what are the documents are under record here.
Why is it necessary?
Because for deciding.
No, no, when you are filing an application under order 12, order 11, rule 12, and order 11, rule 14. Order 11, rule 14 pertains to direction for production of certain documents.
Yes, sir.
Okay.
Sir.
Now, unless you place the plaint, why haven't you placed the plaint? No, no, I think we should not allow this type of petition.
No,
No, sorry, no. We are going to dismiss.
So
this.
you are filling us, you are.
No, this
You are-
appears this is a matter which need not remain.
No, that's the
Absolutely.
record is called for you.
No, not necessary records.
Straight.
We don't require. Here you have not enclosed. What are the issues framed?
Issues you are.
What are the issues framed?
But issues are.
A decree for so and so in favor of the plaintiff against the year compound interest. What is the suit for?
Suit is for what has happened here in the suit. What you find that interest has been charged on NK illegal NK bank guarantee or conditional bank guarantee.
Then
So the recovery of that amount, recovery of that interest and amount which you have been taken out by farm.
so unless we know the plaint, how can we look into it? No, I think we should dismiss it. No, this type of petition should not be allowed. We vacate the stay. This is a stay, I suppose. Yeah, we should vacate the stay. My goodness. We're lucky enough that some good judges are there. And you have also got this thing listed as so and so. We are not satisfied with this.
You're not sure about
No, no. Heard Mr. P. Chaudhary, the learned counsel, appearing on behalf of the petitioner. Mr. So-and-so, who appears on behalf of the respondents. Both,
The personal one.
one. It's two. The present application has been filed by invoking the supervisory jurisdiction of this court under Article 2 to 7 of the Constitution, challenging the order dated
You're also prayer should have mentioned page 13 here.
challenging the order dated 13/11/2023, passed in IA Civil number 1163/2023, whereby the said application was rejected from a perusal of the said application. It appears that the petitioner as plaintiff had sought for direction upon the defendant number 1 to produce documents pertaining to encashment of 4 conditional bank guarantees in favor of the defendant number 2 for the period from 23/2018 to 2/11/2018 and exhibit the same before the learned trial court. Further to that, the plaintiff also sought for a direction upon the defendant number 1 to furnish the particulars of the documents and materials pertaining to encashment of 4 conditional bank guarantees in favor of the defendant number 2 by the defendant number 1 for the period from 23/2018 to 2/11/2018. Available with the defendant number 1. To the said application, the defendant number 1 had filed objections. Alleging inter alia that, stating inter alia that the documents which the plaintiff have sought for is completely vague.
Your Lordship, kindly say.
It is pertinent to take note of that from the very application filed by the petitioner, it is alleged that the defendant number one on 23/2017 and on subsequent dates till 2/11/2017 had there were illegal encashment of 4 conditional bank guarantees. However, the information which the petitioner was seeking for, as well as the documents in the application so filed, were in respect of 4 conditional bank guarantees were in respect of illegal encashment of 4 conditional bank guarantees for the period from 23/2018 to 2/11/2018.
211. 211.
2/11/2018. The learned trial court, by the impugned order, categorically observed that the documents which have been sought for by the plaintiff to be produced by the defendant number one pertains to correspondences that took place between the defendant number one and defendant number two, leading to the encashment of 4 conditional bank guarantees. And the same are not relevant to the matter in controversy between the parties in the instant case. It is under such circumstances that said application was rejected. This court, having perused, heard the learned counsels for appearing on behalf of the parties, and having perused the materials on record, do not find the order impugned in the instant proceedings, order dated 13/11/2000, impugned in the instant proceedings, is of such a nature wherein the supervisory jurisdiction of this court under Article 2 to 7 of the Constitution is required to be exercised. Accordingly,
Your Lordship, I have but it is order to rule 30. The affidavit prescribed here. Yes, sir.
what?
Order 11, rule 30. The affidavit, the CPC prescribed how the affidavit has been filed here.
So,
That has to be recorded. Your Lordship. Otherwise, that is why case has not been taken. Your Lordship. Order 11, rule 30. So can you see?
what is there? I have this. Tell me. What does it say? Let's give it. What does it say?
Appendix, if you go to the appendix level.
Hmm.
Appendix level. Appendix level, see. Appendix, it is number 5, affidavit of documents here. Under order in rule 13. The affidavit has to be in this format here.
So
It has to be, these are not filed in this format here.
they,
Yes, sir.
not necessary,
So you have to record that.
not necessary.
Your lordship will record that.
Interim order passed earlier stands vacated.
Your lordship will kindly
Further
record
to
that.
that, this court directs the parties to appear before the learned trial court on 27th of April
Your lordship,
2006.
you have noted down my objection also, what I level to 13. But that is my specific case here.
That is not necessary.
Yeah,
Why is it necessary? It should have gone under order 11 rule 1.
That is what,
No, Mr. Chaudhary, this is not how you do it. See how it is.
yes, order,
Let me tell you how it is to be done. You move first, there are two aspects. Order 11 refer, one is interrogatories and the second is discovery.
yes, sir.
Order 11, rule 1, you are required to go for interrogatories. Did you go for that? No. Number 2,
Yes, sir.
as to these are the well, should have asked him that these, whether do you have these documents or not.
Problem there is,
Wait,
it is a
if these
task of-
documents